welcome to this panel. I'm very glad that you have come here, and I'm very pleased to be moderating a group of such experts talking about how democracies protect both privacy and national security. We have some ambient noise here from the back, so this will be a test of how well we can focus and concentrate. So I'm very pleased to be joined today. My name is Alex Joel. I'm with the American University Washington College of Law. I run a research project there called Privacy Across Borders. And before I did that, I was for about 20 years in the U.S. intelligence community. 14 of those years, I was the Civil Liberties Protection Officer for the Director of National Intelligence. And those of you who have been following the EU-US data privacy framework will know that there's a key role for the Civil Liberties Protection Officer, which is the position that I used to hold at the Director of National Intelligence. And we are here to talk about one of the core issues that all democracies deal with, which is how do you both protect privacy and national security at the same time? It's not an either-or choice. It's not do one or the other. In order to succeed as a democracy, the democracy must do both. And we've seen that theme, I think, if you've been to some of the other panel discussions here, particularly any panel discussion that's talking about cross-border data flows. One of the key issues that always comes up is government access to personal data held by the private sector for national security and law enforcement purposes. So that's what we're here to talk about. And in particular, the Organization for Economic and Cooperation and Development led a very important effort over the last couple of years to address that very problem, that very challenge. And they emerged with a very important declaration. So let me introduce the panelists, and then we'll get right to it. Right here to my immediate right is Steve Wood. He is formerly the Deputy ICO for the UK, and he led the Data Protection Working Group. What was the name of the Working Group for Data Governance and Privacy at the OECD. Next to him is Audrey Plonk with the OECD. She actually led the effort to come up with the declaration of these principles. And let me get her unit right. She leads the Digital Economy Policy Division at the OECD. Next to her is Ashlyn Kelly, who is Assistant General Counsel at Microsoft and participated in one of the stakeholder groups that consulted as part of the process. And then Thorsten Wetzling, who is with SNV in Germany, in civil society, who writes regularly about the intersection of national security and privacy and civil liberties in Germany, and also participated as a consultant along with me in the OECD process. So let me start off by asking Audrey if she can walk us through a little bit about the background for what happened at the OECD.
Thanks, Alex, and hi everyone. It's great to see you. Thanks for taking the time to come listen to this topic today. As Alex said, I'm Audrey Plonk. I'm the head of digital economy policy at the OECD. My division's responsible for a variety of topics, including privacy, security, AI, infrastructure, communications, connectivity, and a range of other technology policy issues. So. We're really proud of this declaration that was adopted by ministers in December, just a short 5 months ago. But let me just take you back to why we did this and why we sort of went down this path. And it requires really going back to 1980 with the adoption of the OECD privacy guidelines, where in 1980, countries were pretty forward-looking about the challenges that were going to come with privacy and the advent of computing. And so the privacy guidelines were adopted at the OECD, and they looked at they set many of the principles that you know and love today in privacy. But one of the things they didn't do was try at all to touch on national security or law enforcement access to data. And they didn't do it explicitly, and they said explicitly in the guidelines that they weren't going to try to do that those were sort of separate areas of law and access, and that the commercial privacy protection issues were going to fall here, and those issues were going to be separate. It doesn't say it in those many words, but there is sort of an exception or a bit of a carve-out in the privacy guidelines for this type of access. And we lived with that for 40 years, and that was fine. But except that the world changed in those 40 years, and several, again, forward-looking countries, led namely by Japan, put on the table when Steve happened to be the chair of our working party that, wait a second, this is actually a big issue. It's a big issue. It's been a big issue, but it's becoming a bigger issue, and we can't continue in a world where we don't have a common, at least baseline or understanding of how this type of access for law enforcement and national security at least works at the international level. And so, so we took on this project to try to inform that gap, not to change the privacy guidelines, but in some ways to fill the gap that is there for good reasons and whatnot. And so we led a process for the better part of 2 years, not quite, that brought together law enforcement and national security experts as well as privacy experts and privacy authorities from across OECD countries. It was a closed process only to OECD members. We have 38 countries, and we tried to do a couple of things, and I would love to hear when we get to the Q&A part what you think about it. But the first thing we tried to do is identify commonalities in how our countries access and how their legal frameworks allow for this kind of legitimate access for the protection of national security and for the executing of law enforcement duties. So we didn't attempt to say, here's an aspirational view of what we wish the world looked like. We took the approach of what is actually happening on the ground today. What do our laws and policies allow for, and how do they practically deal with this in those contexts? And it took a while to get. We have 38 member countries to gather the data and to analyze the data and to have the discussions on how things really work. And so that was a big part of what we did. But so that was the primary objective. And part of the reason for that objective was to be able to do a few things. One, to articulate how democracies deal with these very difficult issues, despite the need to access data for these reasons, and to potentially draw a line between approaches that are less democratic, or at least governing approaches that are less democratic. And then the other main objective was to try to advance discussions around data flows. And Alex said it at the beginning, as how do challenges around this type of data access affect the broader challenge of data flows, which we have a lot of imperative from an economic and from a social benefit perspective. So I won't spoil all the fun, but just to say the way that the declaration is structured, it has a preamble which sort of lays out why we did it. It has a section on data flows and how this relates to data flows, and then there are 7 principles. And I think at a high level, the principles will not be surprising to you. They talk about legal basis, they talk about legitimate aims, they talk about how to handle data, they talk about transparency and oversight and redress. And so at a top level, you'll sort of say, great, not surprising. But I think the important part is the detail that's underneath and how these 7 principles interrelate to protect privacy and in the context of this type of access. So with that, thanks, Alex, and I'll turn back to you.
Thank you for that background. And I just was I put up earlier, Audrey, as you saw, the member countries. So they're from all over the world. They're not the entire world, obviously. So it's a subset. And Audrey, could you talk a little bit about the OECD itself and why it was perhaps chosen as a place for this? You mentioned the privacy guidelines and the gap as a natural follow-on.
Yeah, well, so the privacy, the OECD is a international organization focused on economic and development and social advancement, and it dates back to the end of the Second World War, and came out of the redevelopment of Europe and the funding and money that came from North America, Canada, the United States to rebuild Europe after the war. NATO became a military alliance, and the OECD became an economic alliance. And over time, that economic alliance has expanded, and so we're focused on building economic prosperity and growing our economies in a way that is sustainable, in a way that advances overall societal goals. And so the OECD does a lot of stuff across a lot of different domains, including education and trade and health, and some of that you might be familiar with. We have an anti-bribery convention, so we have a large range of tools available to us as an international organization. And one of the things we do is create soft law, and so soft law is sort of it's important, an important tool in the international space because it allows to advance on certain issues, particular difficult issues, in a way that is technically non-binding, but represents a strong political commitment when countries sign up to it. So it's not a treaty in the sense that it's enforceable by a court, but it is a strong statement by governments that this is both what they do and what they adhere to in any of our soft law instruments. And so that's the overall objective of the OECD. And with regard to privacy and data flows, I mean, privacy, because the guidelines date back to 1980, they're a core part and foundation of our technology policy work overall at the OECD, which has gone it dates back to the very beginnings of the OECD, and a recognition that science and innovation and technological advancement is a huge contribution to GDP, to economic growth, and to societal advancement. I hope that's what you wanted.
Yes, that's
Okay.
great. Thank you so much. So, so as Audrey mentioned, there's a quite extensive preamble that is worth reading in full because it really sets up the context around where this declaration was coming from and what it was intended to do. And I now, not realizing the setup of the room, I realize now that many of you will not be able to see the text written, so I encourage you to actually pull up the declaration when you get a chance. But here, there are a couple of preambles talking about the shared commitment to privacy and other human rights among the OECD member countries, and the rejection of government access that is unconstrained, disproportionate, and arbitrary and unreasonable, right? So it's trying to distinguish democratic countries with their set of values from other countries that don't share that set of values. And then there are additional preambular statements that essentially try to explain that one of the uses that coming up with this declaration hopefully will serve is that it'll be a common benchmark for countries to evaluate each other when it comes to figuring out whether data can flow freely from one country to another. So let me turn to the other panelists. I wanted to start the general discussion, and we're trying to make this conversational, with sort of what are some key important takeaways that you guys had coming away from the OECD process, and all of you participated in it in one way or the other. And let me start down at the other end with Thorsten, if you want to talk a bit about what you think were the most important things coming out of the OECD declaration.
Thank you, Alex. It was a pleasure for us, Alex, both you and I as a consultant to this process. I thank you for the invitation, Alex, to this panel.
And Theodore Christakis was also one of them.
Thank Theodore. And we wrote a lot of memos, and I think, first of all, it was very enlightening for us to see that there are common principles being applied throughout some countries, that we can see that on paper when we designed the questionnaire. And, I'm not going to say that there wasn't any family drama. It was a bit like, there's this Christmas card picture of the family, and then there is the time when the declaration, and in between there was a lot of drama, and don't want to go into further details, but some important aspects. It was really, there are not that many intergovernmental agreements on common approaches, and having a fact-finding survey, 2 of those, and being so important to distinguish those member countries from authoritarian regimes is also something that is as clear as ever now. And that's something that I really enjoyed. And, of course, that doesn't mean that I don't have notes on things where there's room for more. And, as Audrey said, we're dealing with forward-looking countries, but we're focusing on commonality and not on aspirations. But, some countries certainly have gone further than what is documented in the principles. And, there is a lot of things we can discuss in details. I think if I just can say 4 things, Alex, and we go into the discussion. Of course, there is law enforcement and national security. And at the time with the Russian aggression in Ukraine, maybe not the best time, but of course there is collection by the military, and there's cooperation between national security and the military. And I can point you to references where there's automatic sharing of data through bulk collection with the military, where the data processing and data audits are far less rigorous in some countries. So that's a bit of a thing. I find it interesting, as you point out, Alex, if you can point further up to one more. Yeah. It says, we reject, I don't think that's the one, but we reject any approach to government access to personal data that is unconstrained, unreasonable, arbitrary, and disproportionate. And the further down, they say, we note, as an OECD, stakeholders calls for additional work with regard to purchasing commercially data, accessing publicly available data. And I'm not so familiar with the language of this drafting. Lots of instruments have been published by the OECD, but I note the weather is nice. I'm not so sure that what is the additional work and engagement that will come. It would be interesting to go into that. And just generally, I think I've learned, if you ask that question, I've learned a lot about constructive ambiguity, the importance that governments attach to this. We need to find text that allows us to come together, which is important, but we also have considerable differences. And then the language becomes really important, and there's a lot of wordsmithing that goes into this document. Some cocktail receptions have helped to smooth over some of the things. And for me, I've learned a lot, and just to say commonality exists, and I'm very glad that we've come to have text on those 7 principles. And later on in the discussion, I have some more, but that's just an introduction.
Yeah, so I do want to focus on or highlight just 2 things that you said, Thorsten. One is commonality, and of course, Audrey said this as well, and it's in the declaration. The actual declaration is, we declare the following shared principles as reflecting commonalities drawn from OECD members' existing laws and practices. So as you've heard, this was not intended to be an aspirational document. So that can be, on the one hand, that can be viewed as an issue. On the other hand, it can also be viewed as a major strength of the document. So this is a document that already articulates that these are the principles that these countries hold in common. So we're not talking about speculation. We're not saying maybe next year, maybe 10 years from now. It articulates those commonalities. And in part because of that, there had to be very careful wording, as Thorsten points out. And you have governments there at the table trying to word things in a way that they can say, yes, this reflects our current legal system. So that could be challenging. So let me turn to Steve. What were your reactions? And I know that you were involved in other processes as well while this was going on.
Yeah, thanks so much, Alex, and it's really great to be here talking about this, fairly sort of landmark declaration that the OECD produced at the end of the process. And I was quite lucky, actually, to observe it from a number of different perspectives. So when the process started, as Alex mentioned, I was the chair of the OECD Working Party on Data Governance and Privacy, so I took part in the expert group as the chair from that capacity, so reflecting the views of the data protection and privacy experts, particularly from my working group. I also had a perspective on these issues as well at national level in the UK, because I was the Deputy Information Commissioner at the ICO. So the ICO has a limited role related to national security and law enforcement regulation and data protection, so I was able to bring that perspective in. And then also, at that time as well, the ICO was the chair of the Global Privacy Assembly, which is the international network of data protection regulators as well. And in October 2021, the Global Privacy Assembly produced a resolution on government access to data and data protection and privacy and democracy and rule of law as well. So there was a number of parallel processes going on, and actually the principles that came out of the GPA work, so you can find that on the Global Privacy Assembly website. There's a lot of complementarity between the 2 documents in terms of what was produced, which I think is positive in seeing how, again, there's a synergy between the discussions around what these global principles can be. So that document actually came out first in October 2021, a little bit ahead of the OECD declaration being agreed. So I think the perspective that I've taken away from the document about why it's important is it's really obviously important that this was a discussion which took place amongst governments. So the OECD obviously has representatives from all of the different member country governments there, and the fact that they were able to bring their experts from national security and law enforcement to the table, I think, as has already been mentioned, gives the document a lot of credibility, and that foundation as well of democracy and rule of law, which, as I said, was also in the Global Privacy Assembly resolution, I think is a really important founding part that we do need to emphasize. I think the thing I like about it is its breadth. So I think that the principles are what I would call holistic. So they cover, the range of issues. You can see them there on the screen in terms of all of the different sort of foundational principles you would need in place to ensure that those protections are effective in practice in terms of privacy and data and protecting personal data. So I think the fact that you've got that holistic set of principles, so therefore it has breadth. Obviously, there was a debate about how deep it was going to go in terms of level of detail, and obviously it had to stop at a certain point, and we may discuss later perhaps what may come next. But I think that breadth, I think, is important to it. And I think the fact that there was, agreement on the common principles in terms of some of the language, which previously had been pretty difficult, and perhaps people always said there was always a transatlantic divide or a difference between the EU and the rest of the world. So I think the fact that the words necessity and proportionality, the word disproportionality is in there as well, I think it's really helpful that we are able to sort of coalesce around those words as a global community. I think that's really helpful. Obviously, the language of proportionality is now in the EU-US data privacy framework, which is hopefully going to be agreed at some point this year as well. So I think it's good that we've got that recognition that necessity and proportionality are global concepts. They're not just European concepts, and they can interoperate and sit under this common umbrella. In other jurisdictions, different terms might be used, like reasonableness, etc. But we can see the interaction and how they do complement each other. So I think that's really helpful. And I also think the other important feature around redress as well, in terms of that, of course, has been a difficult discussion point previously. We know from the EU-US context, and the fact that there was the language there, which talked about judicial and the non-judicial routes to redress, and how really, I guess, the combination of those two routes can be drawn together to provide that overall effective framework for protecting personal data and privacy. I think is another really helpful component, and probably the other important thing to discuss. And I think we may come back to that later as well. So.
Yes, and as they're mentioning different principles, I'm going to try to flash them up on the screen, recognizing that those in the back may have trouble reading the screen, so I apologize for that. Aisling, this is all about accessing personal data held by the private sector. As a member of the private sector, what are your reactions to the declaration?
I think from Microsoft's perspective, one of the key takeaways really, Alex, is the multilateral stakeholder approach that was really unique to this process. So it's all very well and good to make law where you're looking for government access to data, but unless you have the private sector in the room to discuss what is and what isn't possible, or to drive, I suppose, shared understanding between the partners, then it becomes sometimes a law which is impossible to actually operate. So having people in the room from the private sector was really key, and there was the International Chamber of Commerce was there. There was lots of great bodies there representing different stakeholders. So that multilateral stakeholder approach was really key. And I think, if I was to pick one of the principles out as our favourite from private industry, it's really transparency, because, industry is really, I suppose, passionate in making sure that the data subjects' rights are known to them. And at the core of these orders, which are being served on my team on a daily basis, is that there are warrants and production orders for data, where the concept is that until the cloud came into existence, if you were having something taken from you by a government agency, you would know about it. And that concept of transparency and user notification is really core to Microsoft's advocacy in this area. And without the ability to know that your data has been taken where appropriate, because I know that that's a particular line in the principles, lots of the follow-on rights and principles are impacted. So the oversight is impacted and the redress is impacted. So the data subject not knowing whether or not they've had data supplied to a government agency, then consequentially their ability to operationalize those consequential rights is severely impacted. So they would be my key takeaways, Alex.
Thank you, Aisling. Audrey, would you mind talking a little bit more about the stakeholder consultation process, and then what were your key takeaways or lessons learned, if you want to share?
Sure, thanks. Yeah, so as Aisling said, we had the process that we ran for the experts group that developed this was closed to governments only, but we recognize and as much as possible work in a multi-stakeholder fashion. And so we engaged with civil society and the private sector in a series of stakeholder consultations in order to get that very practical input. And at the appropriate point in the process, we were able to share a draft before it was finally adopted. So there were some, I think there's, happy to hear reactions across the spectrum. And I think in a perfect world, other stakeholders would have liked to have been actually sitting in the room for the negotiations, and we appreciate that. But this was a very sensitive topic and process, and I think one of the important things that we provided was a sort of safe space for the communities of national security and law enforcement practitioners, people that are actually overseeing or actually processing orders or actually trying to figure out how their laws apply to specific situations in their country, to come together and share their experiences is a pretty tall ask for that community, and not something that they often do outside of a much smaller community, not something that they normally do at a place like the OECD, which is not a classified environment, it's not a secret environment. And so we had to really create a space where we could share information, not secret information or classified information, but just feel safe to kind of work through some of these problems, like, what does it mean to have a prior approval? Prior to what? What does that mean? What about, exceptional emergency situations? How does that work in practice? So we got very tactical, and in order to work through some of those really tactical things, we had to have a smaller community. Which is, of course, not to say that we didn't involve the stakeholders as much as we can, and we certainly did. I think, I share the takeaways of others. I guess the one thing I learned, there's a lot of commonalities, and a lot of things come down to, countries use specific terms in specific ways, in specific policies and legislation, and they can't just change or adopt different terms because somebody else prefers a different term. And as painful and frustrating as that might seem sometimes, it's the reality of the way the world works, because we all have legal frameworks, and those legal frameworks are built on words, that are built on sentences, that are built on paragraphs, that are built on documents. And so we can't just upend a country's entire legal framework because we want to use a different word because some other country uses a different word. And so we use different terms, but we often mean more or less the same thing. And so getting through how do we get to defining a concept that is commonly shared without either using everybody's term or without disadvantaging one approach to another is a challenging topic in any international negotiation, and particularly on one as sensitive as this. So I think, as Steve said and others, it is a big achievement that we were able to draw some parallels between sort of sacred terms in this space to show some real commonality between countries, because I actually, one of the things we learned is there is a lot of commonality, at least at this foundational baseline. And so I learned a lot about the sensitivities and why countries have certain sensitivities, and where, frankly, and you'll see in the document where there's interest in improving and where things are evolving, because these, Thorsten and I were just talking, Germany's laws are changing, surveillance laws are changing around the world fairly regularly, and they have to change, they have to adopt. And so this is it's interesting to hear the countries talk about the challenges they have with their existing laws, where they think it should go. And so we learned a lot in that process. And, to me, this this declaration is really, it's not the end. It's the end of a particular process that sets the baseline, but it's really the beginning of a bigger conversation and a bigger dialogue to be having at the international level that started with the adoption of this, because this is, again, the baseline. It's not necessarily where we're going to go. It's not where we're going to stop. I hope countries will use it. Companies will hopefully use it to help inform decisions and processes that they need to make and fulfill. But it's not meant to be, okay, we did this, let's put it on the bookshelf and move on with our lives. I mean, this is a critical component of data flows, and so it's the beginning rather than the end.
So yeah, I was going to. I know you have something to say on your own, Thorsten, but I was actually going to turn to you with an additional follow-up question first, and then you can
Sure.
jump in with where you wanted to go. This idea of establishing a baseline. You've done a lot of research on surveillance laws and practices. I've done that kind of research. It's not easy to do. Like, tell me a little bit about what you think of in terms of. Well, I'll tell you what I think of, and you can tell me if you agree. I think this was extremely valuable because it's not easy to get an in-depth understanding of how other countries do national security and law enforcement. It's many times it's in public documents, but it's difficult to understand. It's not always readily apparent. It's not always put in a manner that allows somebody from the outside to quickly pick it up. But do you agree with that? And what did you think?
I agree with that, Alex. I think if you think about the global map you put on there, and I think 33 countries, if I remember right, have signed. Yeah,
38.
38 countries have,
And the EU.
And the EU have signed on to this declaration. This covers quite some space where we hear a lot of democratic backsliding and the rest of it. To have those countries, I'm not naming individuals, but you can see at the global map that these countries have signed on to that. That is something, and these are very complex, and it takes time for countries to adopt and to be prepared to have public information out there on their practices. So I agree with that, Alex. The points that I wanted to make briefly is just that I see, of course, there are rooms for improvement. So if you want to go to the oversight principles, just for a second. And you see on the, people cannot read it, but I just feel like this is already quite substantial, if you like, on, there needs to be impartial oversight. So that's language. So countries would have some preferred independent, but we have impartial oversight. And then there's lots of things that oversight bodies need to do. And of course, you can go further. And you could speak about binding powers that you may want to have, oversight powers to have. I personally think it would be helpful to have some sort of an annex or some guidance for further countries to what that means, because you see in the language oftentimes may include or such as or as they may apply. So sometimes it doesn't really give you that much granularity. For instance, when it comes to access, oversight bodies' access to the databases and the IT systems of the services not addressed. They can develop control programs. They can use supervisory technology and have binding powers. And I just briefly want to say something, because this is for me studying, oversight practice. But it's also interesting that other institutions, such as the European Parliament, have also come forward with a recommendation as regards their inquiry into Pegasus surveillance spyware. And, they say that exceptions to some of the principles dealing with the processing of data by intelligence and security services, that exceptions and restrictions must not interfere with the independent and effective review of supervision. And they say that effective review and supervision implies binding powers, where the impact of the fundamental rights is the greatest, particularly in the accessing, analysis, and storage phases of processing data. So, for instance, some oversight bodies, they can order the deletion of data if it was shown not to be of use, or if the services hold on to data longer than they should, and they can get push notifications that look, this data should have been deleted, but it's not. Some oversight have binding powers, and the European Parliament recommends in its text that this is part of this. And they also say, and last thing, Alex, a lack of, and that's interesting, a lack of binding powers of oversight within the domain of national security is incompatible with the criterion that this constitutes a necessary and proportionate measure in a democratic society. So binding powers is really something. And they go on, just two more things that have not been, where I think we can, if we look forward, see some text. Intelligence cooperation, obviously, is a big issue. And the European Parliament says there should be standards developed, including the issues of oversight bodies being considered a third party under the third party rule or the principles of originator control. So that when it comes to intelligence cooperation, oversight bodies are no longer considered to be outside of this, and they need to have access to shared intelligence. So if data is shared, it can be overseen. And that is something, I'm just trying to be constructive, Alex, here. This is something where we could look towards further development from within the envelope. We have this formidable instrument, the OECD Declaration, and there's certainly room for more and appetite for more, certainly by the civil society, and maybe
right. But and I would say so. That's in a resolution of the Parliament, right? So I think this is clear, but that would be more aspirational, or at least an observation as to what they think should be the case. Whereas the OECD principles were dealing with commonalities in existing legal frameworks. Yeah. And we were going to have another representative here from the national security side, but he was unable to make it due to a national security matter that he was dealing with. So,
Can I respond?
Yeah, go ahead.
I just want to say that on Thorsten's point about some of the points that he just made, which we did discuss a fair amount, and completely agree. I think what we found is that when you're dealing in the domain of both national security and law enforcement, which are both fairly broad domains, and each of those domains have fairly different objectives in their access to data, how they handle it, process it, what they're ultimately trying to achieve, whether they're trying to keep a secret or whether they're trying to prosecute a crime. And those are different objectives. And so when you start to talk about oversight, for example, what we found, and we did, Thorsten mentioned it, but I didn't, we did conduct a survey of countries, a fairly extensive survey of countries, in order to try to help people see help countries see the commonalities. And what we found is that there's such a wide range of functions and entities that countries view as oversight, if you're talking about national security and law enforcement, that unless we were going to get detailed about an internal oversight body that is overseeing whether the policeman executed the right thing when they did the traffic stop down the road versus when a court oversees something, that these are really different functions, and that the tools that they have are different. And so that's part of the reason you don't see some of the higher standards that Thorsten's talking about there. And so I think, one of the things we found is that the level of granularity, we had to stay at a certain level in this initial commonality, but that perhaps in the future there's usefulness in looking at different types of oversight authorities and what their powers are, and the powers that are different, because not every single oversight authority is likely to have binding powers, but maybe a set of them should have binding powers, and who should those be, for example. So that detail's not in here, but I think it's something we did tackle, at least at a substantive level, and pushed countries on, and I think we learned a lot about the range. And the same was true in other areas like approvals. We struggled a lot, I think, actually with approvals, because this idea of how do you get approval to access data, that there's a wide sea of reasons you get access to data, and the process for getting approval is really dependent on a whole bunch of things. And so we, some of the principles that you might say, yeah, okay, fine, everybody, you get approval, great. But actually, once you start to think about what does it mean to get approval, do you get approval beforehand? Do you get approval after? Do you get approval by 10 people? Do you get approval by one person? Like, where are the controls in that? And who approves, and why, and what, and under what circumstances, and what reasons? It's not a simple task. And when you're talking about, a law enforcement authority in, Korea versus a law enforcement authority in Mexico, I mean, these are different, very different cultural and legal systems to find a commonality from. So that is really just a long-winded way of agreeing with Thorsten and saying that I think that there's a lot of that hopefully this opens the door to a deeper look in certain areas where we can continue to unpack what is, a very complex landscape.
Yeah, and I wanted to also invite Steve or Ashley to weigh in on any of what you've heard, or if not, I can keep going.
Yeah, I mean, I feel slightly rude saying about what is either missing or what we're looking for
please.
additionally. But I mean, I think
You're off the panel.
one of the things I suppose that we would see on a day-to-day basis is where a law enforcement agency in one state submits an order, or an intelligence agency in one state submits an order where the laws of another state or other states are impacted. And so private sector entities are placed in a position where they are basically looking at which country's law to abide by. And so I think in the future what we really would be, I suppose, aspiring to, and I'm very conscious of the work that the principles are, they were codifying or recognizing the existing norms. But what we need to look at, I suppose, as a community is a global conflict resolution mechanism for these situations. So private sector entities are not placed in positions where they're asked which country's laws they're supposed to abide by and which country's laws they're not. But that is something which I suppose we wouldn't even be getting into the conversation with, Alex, unless there was the OECD declaration, because it's provided such valuable and fertile ground of conversation with governments that I have on a daily or weekly basis where I'm saying these are the principles which your government has signed up to. I think it's really incumbent upon you to internalize them and operationalize them. So
you've actually had practical use for the principles already.
Yeah, I've had a couple of interesting conversations with government where they've been trying to legislate in this area. And I mean, it's a truism. Anyone who's worked in government will know that it's impossible for every single government agency to know what other government agencies are doing. And I think the OECD declaration with some countries some countries who came to the table and had a very integrated approach to their government's knowledge, and they had a very collaborative. They went back to their own national states and had a collaborative approach. Other governments may not have had, and so the practical experiences where perhaps one ministry has signed up for the declaration and another ministry is legislating for these areas, and they don't know what their actual government has signed up for. So I've had those experiences.
Yes, we all have. Yes, go ahead, Steve.
Yeah, thanks so much. I think chip in a further point about oversight in terms of, I think its importance alongside redress as well in the sort of the framework of the principles, and I think particularly reflecting on the unique nature of national security, intelligence gathering, and law enforcement data collection and access as well, in terms of the particular exceptions that need to be in place so that those activities, legitimate activities, can continue unimpeded through, excessive transparency in terms of the way they do have to operate, obviously, below the radar. So in terms of that secrecy that is needed in certain scenarios. And therefore, obviously, the role of oversight and redress is particularly important in terms of its effectiveness, because the citizen, the individual, has less visibility of that. So therefore, I think in terms of that, further work that could be done, that the panel have been talking about, in terms of commonalities and mapping out how these oversight functions, the commonalities and how they are implemented in practice, I think, could still be a really helpful resource to be able to be shared, amongst the member countries and other countries who are looking to, reform and improve their implementation of oversight and redress as well. The other thing I would mention as well, and it probably was too granular a point to be caught in the declaration, is the issue, of the access to larger data sets, often called bulk collection. I think obviously it was, probably too detailed and sort of too fine a point to go into in the declaration itself. But again, I think understanding the common practices around bulk collection and how bulk collection sort of interfaces with necessity and proportionality, I think is a long-standing issue. I mean, some people see them as sort of diametrically opposed, but I think when you actually look at the evidence, there is obviously a path through that's been found in many jurisdictions in terms of approaching bulk collection within these sort of common principles as well. So I think that's an area which will often be, I think, of concern as well to civil society. And I think obviously you can reflect in the declaration, but the countries who have signed it obviously have rejected, disproportionate and unjustified and indiscriminate collection of data. But how does sort of bulk collection sit in that area? I think it could be another sort of, further area where the common practices could be helpful to draw out in a bit more detail.
So I have some more questions for the panelists, but I do want to encourage, we can start this early. If anybody has a question, please, we welcome questions from the audience. Okay, we already have some. Great, go ahead. Can you please identify yourself and then ask a question?
Hi, my name is Vania. I work for CDT, Center for Democracy in Europe. I have a question related to how do we get approval exactly? Could you give me examples of how do you get approval access to data of these countries? I understand that, of course, you have to take the principles of necessity and proportionality into account, but can you give me more concrete examples of how do you get these approvals? Thank you.
Okay, sure. I can answer that unless one of you. So this principle is one of the general points I was going to make is that when you look at even if you look at the principal headings, they look familiar, but they're not exactly the same as what you would see in fair information practices or in the fundamental rights kinds of things, because this is about law enforcement and national security. These are principles that are important in that area, and one of those is approval. And what they mean by approval is there are varying types of approval that a government official operating in the national security law enforcement context in a country might need in order to go to a company and ask for data or try to get data or to use a technique. And it's basically a spectrum. So if I want to look at something in the newspaper, I don't need approval. I can look at my newspaper and get information from that. That's it's very necessary, proportionate, very light, and very non-intrusive. If I want to wiretap somebody's phone, I need to go to a court, a judge, and get approval. So that's intended to reflect that entire spectrum. And the need for an officer to get approval is considered a key control by governments around the world in terms of how they make sure that these powers are not being abused. It's not, when a company is thinking about can I use data for this or that, the concept of approval might be, well, do I have to go to my CEO for approval? That doesn't really become an issue. It's more about consent. Do I have consent? Do I have a legal basis for doing it? But in the government, when you're thinking about deploying an intrusive technique, one of the key controls is to keep on going up the chain and maybe outside the chain to some other body to get approval as a way of making sure they're not abusing that. Did anybody want to add to that?
Briefly, Alex, I think you're right. And, there's a lot of text that went into the approval section. And I think where one might think for additional development is this idea that has been pronounced by some courts of additive rights infringements. So practice by law enforcement and national security often involves taking from different methods of collection, some from direct access, as Steve said, bulk collection, or from indirect or voluntary access, and then from compelled access. And these types of data then often tend to be used in cross-system information analysis tools where they come together. And a thing that, as Alex rightly says, may look very innocuous at first sight may become a bit more a graver infringement if it's used in combination with other collection tools. And that's why that you need to be sensitive to this risk and work on having oversight bodies and those who give approvals to give a very comprehensive view of the entirety of surveillance measures that are in operations for them to assess the proportionality of an individual additional thing to be added to the fact.
Yeah, and a great example, you had a panel about this earlier, Thorsten, about publicly available information, commercially available information, not areas that countries have developed a whole lot of laws around in terms of how to control access, trying to figure out what those issues are. Looking something up in a newspaper is innocuous. We expect our agencies to be up to speed on what the media is saying. Then maybe you look at somebody's bio on LinkedIn before you invite them in to meet with you in your office. Well, okay, that seems fine. Now you're deploying massive tools with advanced techniques and combining a lot of different data from different sources. It's all still public, but now you're using these advanced tools. At what point have you crossed a threshold? And I think that's an area of further work, and I think further work in many of our countries as well to figure that out. Yes.
Thank you. My name is Charles Robb. I'm at the University of Edinburgh and also a fellow of the Alan Turing Institute. And for these purposes, I'm also a member of the Biometrics and Forensics Ethics Group in the Home Office. I'm glad you touched on law enforcement, and I was particularly interested in, you talked about the difficulties of exchanging data across a variety of different law enforcement organizations in different countries. And I was wondering, and this is my question, whether, I mean, those sorts of exchanges very often go on through memoranda of understanding and protocols and things like the Perm Agreement and so forth. And I wondered how those sorts of arrangements sit alongside what you are doing, what you have done. Are there consistencies or inconsistencies between those two domains of enabling sharing across national boundaries? Thank you.
Yeah, that's an interesting question. And I'll invite anybody here to, I'll just give my own quick reaction and then maybe people can react to it. So this effort was really, looking at commonalities of the government within the OECD member countries of their legal systems. How, in the context of those legal systems, they are allowed to share information sometimes across borders. So one possible way that this could help in that process is when next time you're sharing information across borders, does the country that you're sharing with observe these legal principles? This can be a template for going through that and making sure that your bases are covered, and if there's a particular concern because of one of the principles isn't covered, then you would address it. I'll say in reality what happens today is a lot of this is ad hoc, right? So country A wants to get data for country B, they enter into, as you pointed out, a memorandum of agreement or some other document. They try to get assurances that the information will be used only in a certain way consistent with the sharing country's values, that they won't be misused. If the sharing country doesn't trust the recipient country, they're not going to share the data, or they'll put all kinds of restrictions on the data. So the idea that, we'll talk about this going forward, is like, how can these be used in the future? One potential use is as a template or checklist, or as a way of focusing concerns around, facilitating sort of what Aisling was doing. It's like, wait a minute, you signed up to this. I want to see how your laws stack up. Wait a minute, I'm particularly concerned about this principle, and I want to better understand how you meet that. And we have an expert on law enforcement sharing over here, Professor Peter Swire. But before we go to you, Peter, does anybody else have a comment on that? Okay. Yeah.
Hi, Peter Swire. I'm also a research director of the Cross-Border Data Forum. And I've been trying to listen to what might be next steps from this process where there's been so much learning. What I've heard so far today is perhaps something more on bulk surveillance and talking about that. I heard Alex was talking about what's either publicly available or commercially available, and maybe there's rules around that. Another thing I've heard is companies have to do transfer impact assessments and try to figure out how to look at government access around the world, and this list could be potentially very helpful in documenting that in various ways. What could you all share about, you've gotten to the declaration, you've done all this intensive work, you've brought law enforcement, national security, data protection together. What all might you suggest for as useful next steps to sort of further the progress that you've been on? Thanks.
Thank you, Peter. That's perfect segue into our next topic. But if anyone here has thoughts to offer on next steps, please let us know. But let me turn to the panel. Does anybody want to start off on that one?
I can tell you what we've been talking about and thinking about at the Secretariat at the OECD, but I really do welcome ideas. So one of the things that we're particularly good at the OECD is building an evidence base. It's all about data and understanding. So I think what we'd like a natural place for us to go with this is to try to understand how these principles, either through mapping different approaches, in a purely factual, not negotiated, just let's look at different countries' laws and sort of map them so it's easier to understand if you're a researcher or if you're a company or if you're someone else. Okay, how does Finland look at transparency? And if I want to go to their legislation. I don't speak Finnish. How am I to understand? So I think there's some really practical foundational work. And as I said before, because these laws are constantly changing, the sort of need to keep that like up to date and mapping them to these principles is one sort of, I think, low-hanging fruit area that we could pursue. And in order to do that, I do think we would need to work, with the countries directly, because as Alex said before, it's not always easy, even if you're an expert on the issues, to sort of read another country's law that uses different terminologies, has a different context, don't necessarily understand how these bodies interrelate in a complex intergovernmental structure. So, I think there is some useful work to be done there. The other ideas that we've had are sort of trying to look at trends in OECD countries more broadly in areas where data is publicly available. So, we've been talking a lot about oversight today. So the idea that, and Thorsten is really the person to say, but the range of oversight authorities that exist, we know they exist in all OECD member countries. We know that they, to some degree, they issue reports, and we could start to really look and analyze that in order to sort of look at, broadly speaking, across the OECD at meta trends around what oversight authorities are finding and what they're doing, and where, for example, where they're finding problems and where they're finding not problems. And that's the kind of sort of cross-comparable aggregate data that we're pretty good at gathering qualitatively and then also analyzing. So I think that is all to say that I'm looking at ways, or we're looking as a team at ways, how do we build some additional evidence behind these principles, not so much to pass judgment, not to assess in any way, but to provide information to see what's happening and how things are evolving, because I think that's the next step toward, pushing on some of the areas where we might want to get more granular, which we've all mentioned a few ideas. So, but we're very open and would love to hear other creative solutions or concepts, or as those of you living out in this space, like, what do you need? What would be helpful for you? If you're a company and you're trying to navigate some of these thorny issues, like, what do you wish you had? Or if you're a privacy enforcement authority and you're trying to deal internally with your national security and law enforcement agencies, what do you wish you had? And I think helping us hearing what those of you who are out there sort of day to day dealing with these issues, what you wish you had in a perfect world, would give us ideas of how we can better help you, because that's why we're here.
And I think there are some ideas I just want to throw in, because there's a role and importance for civic oversight. So the role of the media, the role of the civil society organizations, and they can also take this as a template. If you are in, just mention any country like North Macedonia, or you are in Ukraine at some point and wondering about the criteria for accession to the European Union. This, at the very least, is a warming exercise. It's not, as we heard, it's not as granular, and I think there's a risk also of being Eurocentric in this. This is global, so lots of the European language has arrived in this declaration, others not. Is that good? Is that bad? That's not for now, perhaps, but I think you can use this for capacity building. If there's no disclosure of that, if the legal basis doesn't include at the minimum this, then media and civil society can put pressure on those governments to say, look, we've learned that others nearby have signed on to this declaration, so maybe you should too. That's the minimum. And also, Alex, you and I and Theodore, we put a lot of work into annexes, documenting how individual standards play out in different countries. Towards the future, one could think about a guidance note where language says it may include, where applicable, and where does it apply? Where is it necessary? And then can give concrete examples. The declaration has some examples. Don't get me wrong, there's some in it, but maybe there could be further stuff in that line. And of course, yes, as Peter also mentioned, you could think about definitions going forward of what is publicly available. How do countries define publicly available? Do purchases on the darknet, is that publicly available or not, or other things? And also commercially available data. When do you use the government's credit card, and when can you not? And there are standards for it. So there's room. Just some ideas. Yes, thank you.
Yeah, I mean, at the risk, Thorsten is saying we don't want to be too EU-centric, but at the risk of just piling in on that, like the area of government access to data is being legislated for with the e-evidence legislative package, and part of that includes an enforcement mechanism in order to make sure that that law is implemented correctly. And so one of the ways in which member states could marry the two obligations of oversight and enforcement would be to ensure that the OECD declaration is used to inform those pieces of transposing national legislation in the EU, because they're going to be working and investing a lot of time and money on operationalizing e-evidence in the next 3 years. And so I think that this is a great opportunity to make sure that the oversight principle is fully embedded into EU national member states law.
Yeah, that's a great point. Steve, did you have any thoughts on next steps?
Yeah, just a last point, obviously reflecting on my new role now, but I left the ICO last year and I now work in the private sector as a consultant, including I work some of my time with a law firm, Allen & Overy, so I'm now working with private sector clients and, seeing how they're having to invest, a lot of energy and resources into data transfer compliance, and they are looking for really, practical things that can aid them in the task. So I think Peter's question is quite a good one in terms of where the data protection authorities and other data protection regulators could sort of pick up on the existence of the OECD declaration now, and potentially consider, could it be referenced in regulatory guidance? So, the transfer impact assessment guidance, or in the UK context, we have the transfer risk assessment guidance as well. So I think, there's an opportunity for lots of different stakeholders to now pick this up and try and see what they should be doing with it, as well as all of the great work that Audrey's talked about that OECD may do next. So I think that's important. And also I think in terms of the actual adequacy type process, which takes place in a number of jurisdictions, not just the EU, but obviously given what the declaration says in the preamble about the relevant countries who have got that type of process in their legal framework taking account of the declaration when they're doing an assessment of a third country, it would be really good to see some concrete examples of that actually starting to emerge. So for example, in the UK government has like a manual that it uses for its adequacy type assessments. Obviously it's a separate process to the EU. So it would be great to see the UK government actually referencing the OECD principles in that manual it uses. And also potentially as well, when data protection laws are being reformed, there could be a possibility in sections relating to international data transfers, if relevant, to be able to reference this. So I think, there are lots of possible opportunities, but I think it's really important to spread the word about it, standing here today, because lots of people maybe are still quite perhaps unsure about its background, how it's come about. So it's really important to get the information out there.
And the beauty is that this is a product that's out in the world. It is what it is. It reflects what it reflects, and it's there for everybody to use. And you can use it in a number of ways, and it reflects the actual laws and practices, according to the vote at the OECD, of all those member countries, right? So how is that useful? I mean, we know that government access to data is always raised as one of the intractable problems affecting global data flows, and companies can't contract their way out of it. But we have this declaration, we have these commonalities, how can that help in the process? So it's not something you have to wait for the OECD to do the next step on. Yes?
Thanks so much to the panel for a really fascinating discussion. My name is Nordy Lidjon. I'm from the Institute of Advanced Legal Studies at the University of London. And I just want to pick up on the point that you made about future projects and statistical evidence and an evidence-based approach, which I think is really welcome in this space. I'm going to go a little bit negative for a moment and say that gathering evidence and statistics from law enforcement and national security is one of the most challenging tasks for oversight bodies, but not just oversight bodies, but for legislatures and parliament and other bodies tasked with actually assessing the impact of these surveillance measures. And at least in the private sector, and Ashley can speak much more to this, there are public transparency reports about access from public authorities. But we've had no fusion of the public-private space and interaction. So any statistics on that would be very welcome. And then in terms of future projects, one suggestion I would make, it doesn't sound all that exciting, but if we add another principle to the OECD declaration on review and statistics, And again, I know it doesn't sound as exciting as it could. I'm going to work on that title, but not to stay Europe-centric, but the EU and a lot of its legal instruments, they have tried to incorporate this. You'll have seen this in the Data Retention Directive, e-privacy, now with the e-evidence regulatory package, but it has really struggled to gather these statistics from member states to date, and there's a lot of challenges there. Capacity, resources is really significant, and I'd be very interested to hear from the panel, particularly from Steve Wood, as to how this process could be improved procedurally and on a long-term basis. Because otherwise, we'll come back to this very vexed question about the actual necessity and proportionality of these systems, particularly bulk surveillance, that this particular document really emphasizes as quite a significant set of principles, necessity and proportionality, and not just Europe-centric.
If I may, just quickly, and I know we're over time, and I'll let
No,
Steve.
I don't. I think we go to one.
Oh, we go to one.
Yeah.
Okay. Oh, sorry. I thought we had only 15. First, just to say thank you for raising those points. And actually, it's very exciting for us because we love statistics, and it's what we do at the OECD. And so we love the title. You're preaching to the choir, speaking to a converted audience, or whatever. But you're absolutely right. The data is extremely hard to get, and I don't mean to at all suggest that we're going to be able, overnight to wrangle information directly out of the national security establishment, or that we're necessarily going to be able to directly assess impact, which is always the holy grail of statistics. And what's a causal relationship, what's a correlative relationship. But what I do know is that we don't have much today. And even in basic things. So I'll draw a corollary example to a project we have on terrorism and violent extremist content online. And so we did benchmarking reports over the course of many years after the Christchurch shooting, and we found, not surprisingly, that yes, while companies issue transparency reports, they don't tend to issue them about this type of content specifically. And when they do issue them, they don't issue them at all similar ways, with similar timeframes, with similar metrics. And so it's impossible to tell or draw any conclusions across that. So we developed a framework for transparency reporting so that hypothetically all of the companies, anyone that's reporting on this, could report in a consistent manner, such that we can make that available, that data publicly available for researchers, for governments, for parliaments, for anyone that's trying to look at, what is this problem space? And, not surprising, the companies don't want to report in a standard way, so nobody will use it. And what we need is the governments to take that common framework and say, you have to use it, or we really want you to use it, or, you should really use it. So I draw that, that example because this is a persistent problem across a bunch of different domains. And if we're going to just take the point you make about transparency reports, the companies do transparency reports. Many do on government access requests, and some governments do transparency reports on themselves. And so, yeah, could we fuse those together? And so it's a great idea. We haven't looked at doing that yet. We could try to see if companies would start reporting the same way, so that we could look more consistently across the companies that do report on government access in a cross company comparable way. And I don't know, maybe they'd be willing to do it in this space, even if they're not willing to do it in other spaces. But I think these are, we won't get to impact overnight, but I think we have to start putting some data behind areas where we can get information. And I think then if we start to get that, the one thing the OECD can really help bring to the table is to put this in front of governments and make a compelling case about why they need to either press their industry or encourage their regulators or whatever to either, make this a principle in the thing, or legislate that you're going to provide data. And so I guess that's a long way of saying, I think this is a really good suggestion, and I think we thought a little bit about the transparency reports on the company side, but I hadn't sort of taken it to the next level. So I'll take it back, and we'll add it to our list of what our next projects could be.
Great. Thorsten, I know you wanted to say something, but your name was dropped, Steve, so did you want to jump in?
Thank you. I think Audrey's given an excellent answer there. I think I'd also recognise there are lots of different sources of the data from companies, the oversight bodies, and governments themselves, maybe other actors as well. And so it's how it's all sort of plugged together, and you have some consistency to be able to do some comparison, to be able to understand understand the data. And I think the other thing that probably would help as well would be, thinking about open data. So thinking about, standards as well for just how the data is published, I imagine might make this task more straightforward as well in terms of being able to harvest the data, get it into spreadsheets and analyze it as well. So I think some practical things around data formats as well would be an important component of it as well. I think it is generally a problem, I think, not just in the sort of national law enforcement space, but also, data protection generally about the implementation of the GDPR. We don't have a very good evidence base there either. So I think it's an important wider question. It was something we did look at the OECD a while ago as well about, common mechanisms to report about, cyber breaches as well. And again, it's a problem in that area. And I think we've got to get, as you say, it's sometimes a less interesting conversation to some, but unless we get that evidence base right, we need to sort of build it sustainably as well. I think maybe, you've got to probably just start with standardized formats and fairly just, at a high level, smaller groups, and over time build it up, because that's the other thing as well, is I think if you start too ambitious, then you sort of scare everybody off. They say it's burdensome. It doesn't happen properly, and I think open data initiatives around the world stall when they try to publish too much too quickly. So I think it needs to be sort of a long-term program and a project. Probably it needs some funding and help, maybe internationally as well.
So let me just jump in and say that as a long-time former intelligence officer, I get nervous hearing some of this stuff just because this data can be used to sort of work out, certain sensitive information in terms of what intelligence agencies are doing. So yes, sometimes intelligence agencies keep too much stuff secret, but they're doing that because they're trying to protect core secrets that could, if disclosed, harm their ability to carry out their job. So that's why these principles aren't the same, just to point out, as the data protection principles in the broader world, is because there is a need for secrecy. And once you accept the need for secrecy, then it changes how some of these things play out. Yeah, go ahead.
Just briefly, Alex, because I think you, as a long-term former intelligence in the intelligence community officer, know that sometimes initially they were scared, but then there's been a lot of progress made,
Yeah.
right, with things on the record and stuff. And so I think you put that in perspective, and I think I may have solved the title for the 8th principle, looking at the G7 and its DFFT. Maybe we can come up with an institutional arrangements for statistics. So IAS, Audrey, keep that in mind.
Thanks, Thorsten. Thanks.
Would be nice. And and I think, just on the slide, since you have it up on transparency, it says, for instance, regular reporting by governments and, where applicable, individual notification. So you can go to your government and say, where do you notify? Tell us. And if you have good practice, you can collect them. So a little punch, there's a website, intelligence-oversight.org, where some countries have, we've collected good practice. Of course, that's part of our studies, but you find from various countries in democracies on some of those phases in the bulk collection sphere, where there's good practice, and you'd be amazed. There's actually a lot of good practice. A lot of countries have gone through a lot of reforms for rights-based surveillance, and they tend to be shy sometimes about it, but you can push them a little bit further and say, as regards some of the progress you've made, you need to be more frank and outspoken about it.
Great. Okay, I think we're out of time, so join me in thanking our wonderful panel.
And our moderator.
And a moderator.